the jurisdiction that you file. If that's the case, fill that out and request a process server. And what will happen is, once the summons is prepared, then they'll contact you. You give it to your process server, and they will serve your ex-wife on a date and time that you choose. In Missouri, if you have a child that is 21 years of age, under the current law, which has just been enacted this year, that child is emancipated. You're no longer obligated under the law to provide support for the 21-year-old. If you have been supplying child support for the 20-year-old since he or she attained the age of 21, then you're going to want to ask the court to give you credit back for that, so then you can execute a judgment against mom. Because she would have the duty to let you know that she's emancipated, but if not, then you need to file the proper motions with the court, and in that case, you would ask the court to go back and give you the credit for the months in which your child was 21 that you were paying child support for. Or you can use that as a credit towards your current child support payments. The next question states, in brief, the woman I had a child with, which he has never seen, is working full-time, moved across the country a couple of times, and is getting child support from this individual and 2 other people from a previous child. And it appears that she's trying to seek an increase in his support payments. Wants to know any type of strategic advice as to how he can find out what the amount he should be paying and keeping it at this amount. And does the fact that he has not seen his child have any bearing on the situation? Well, this question is pretty loaded, so I'm going to try to break it down and we can dissect it and take out and extrapolate certain issues from there. First, being dependent upon the jurisdiction, it doesn't necessarily state so in this question, so we're just going to use Missouri as a jurisdiction. But again, I ask that you check your state and local jurisdiction to determine what the proper procedure is to reduce child support awards. So here in Missouri, if mom is trying to get an increase in payment, she's going to have to prove that the needs of the child have increased, that your income has increased, and her income potentially has decreased. That's not saying that that's the order that it has to be in, but the mere fact that your income has increased is not going to grant an automatic increase in the child support award. There's got to be, once again, that threshold has to be met of 20%. Once that 20% threshold is met, the mom can seek the court to intervene and increase the child support payments. Now, she's going to allege that your income has increased substantially and her income potentially either has not increased or has decreased. And that's going to be an issue that you're going to want to do some discovery on, because you want to find out why mom's income has either not gone up or has substantially gone down. If she intentionally decreased her income to receive more in child support, the courts can take that in consideration and may deny her motion for an increase in child support. I'd have to see a copy of your actual decree to determine what the current visitation and custody arrangement is, which was ordered by the court. If mom's not letting you see the children, and there's a court order which states that that the court is giving you visitation with your children, and mom is denying you access and visitation, then your remedy would be what's called a motion for contempt. And so if you're being denied what was ordered pursuant to the decree or paternity action here, then your motion for contempt will be filed as how we discussed earlier on the motion to modify, except as will be denominated a motion for contempt. File your motion for contempt and an order to show cause. Have mom served, and then you're alleged pursuant to the paternity order, pursuant to the decree. Either way, it's a final order by the court. So pursuant to the order, this is what was awarded to you, this is what you have received, and this is what you're being denied. And based upon that, you're going to put in there a fee, you want to put a request for attorney's fees, because before mom intentionally willfully, contemptuously violating this order, you wouldn't have had to expend attorney's fees to get the time that was due to you to see your child or children. In addition, you're going to put a claim in there for compensatory time, in which the court will award any time that has been missed to be made up expeditiously for you. The next question states, I am pretty much a stay-at-home dad with a full-time job. I work nights as a police officer, and I work on average 12 nights a month. So my question is, what are the odds that I will get custody of my 2 boys that I pretty much raised myself, since my wife works Monday through Friday, 8 to 5? Here in this question, it would appear to me if you're trying to get sole custody or primary custody, custody will be in dispute. So a court may on its own motion for a guardian ad litem, or you may want to file a motion for a guardian ad litem, which we talked about earlier, which is another lawyer who will represent the interests of your child or children. And if you're seeking primary or sole custody, which is what it appears to be asking in this question, having a guardian may be to your benefit. And so you'll file your motion to have a guardian ad litem appointed. The court will appoint one, and then he or she will, like I said, represent your child or children. You'll want to meet with this guardian to explain that you have been the primary caretaker since for your child, either since birth or for a previous amount of years. Here's what you do, here's what's been going on, and here's what you plan to do. You want to go in there with a proposed parenting plan on giving mom visitation, because in Missouri what the court's going to look at is what parent will give frequent, continuing, and meaningful contact. You don't want to go in there saying, well, I've been the primary caretaker and I want to be the sole custodian of my child or children, and mom can have time every now and then or no time to mom. The court may actually award custody to mom. Mom is going to be willing to say, I may not have been the primary caretaker, but I have helped raise my child or children, and I'm propose that I don't want to deny them access to their father. So you definitely want to go in there being able to say, maybe not necessarily any complimentary things towards mom, but you don't want to exclude mom from the child rearing process. You want to be able to at least give her some type of visitation, whether it be the standard. Traditionally in Missouri, it's one night a week for a couple hours and every other weekend. But you want to go in there giving some type of an idea or plan moving forward for mom having some time with the child or children. What I see here is problematic is mom does work Monday through Friday 8 to 5, and I don't know how old the children are as well. It doesn't state that. If they're children that are in school age, there's programs before and after school that can accommodate, which would probably bode well for mom. The fact that you work on average 12 nights a month, which is just a little bit less than half, depending upon when those nights are, and exactly what the shift is. If you can propose a plan to where maybe some of those nights they're with mom and then the rest of the time they're with you, or if you can propose some type of guardian or caretaker or some type of babysitter or someone that would be able to watch your children while you're gone, then that would probably bode well for you as well, just to make sure that you can ensure that they're timely at school, that they're getting their homework done, they're taking their baths, they're being fed, and get to bed at a decent time. You want to be able to be there for your children, and the fact that you're not going to be there for 12 nights may not fare well for you if you're trying to get sole or primary custody. So you want to go in there with a plan that these are the nights that I work, here's the nights that I think that mom should have, and then on the other nights, here's the arrangements I'm going to have, and here's the person who's going to help me. So then you can go in and move forward and have a plan. I think that would help you in the long run trying to get primary or sole custody of your children. Nothing is a guarantee, but at least it will help facilitate your argument for that. The next question states that no papers were filed, but you're curious as to how to gift something with no title, for instance, a scooter or a golf cart. The person receiving the gift is 18 years old. Would you make a bill of sale, write a gift, and have it notarized? Here you can either do a bill of sale and have it as a gift, or you can just execute what's called a gift affidavit, at least in Missouri, and present that to the person who you're gifting it to. And that way, you should be in compliance with the IRS rules. However, I would check what the lawyer practices in tax law just to make sure that you're compliant. So when you file your taxes, if you get audited, there won't be any type of penalties or assessments ordered against you that you would be obligated to reimburse and pay for. The next question states that I supported my ex for 15 years for her to earn a PhD in molecular biology. My ex has received 80% of her life savings. I pay her 17% of my gross pay in child support for our 10-year-old son. We have spent over $10,000 in attorney's fees. I am 51 years old. Now she wants to take me to court to force me to pay for a private school I cannot afford. The decree states I'm obligated for half the expenses of a school to which we both agree. If that's the case, then if the decree states that you're obligated for half the expenses of a school to which you both agree, the key word is that you both agree. If you don't agree on this private school, then you're not going to be obligated to pay for the expenses, but you don't want mom to enroll him into the school and say, fine, you're not obligated, but I'm still going to enroll. So I'd have to take a look at your decree. The way that that it's phrased in the question